John, I came off active duty in 2014, and since then the Army's instituted a new program. It's called the Army Adverse Information Program, or AAIP. And that's a program where if you have substantiated findings that are adverse, so an adverse finding in an investigation, they upload a summary of those findings into your official file. And they do that, my understanding is because they want promotion boards to be able to see what the investigations of the past revealed in their findings.
That's right, and it's a tough thing to navigate because, as you said, adverse findings can come from any credible, officially documented investigation, which can include AR-15-6 investigations, law enforcement investigations, military police investigations.
Right, and so credible information only has to be to the level of a preponderance of the evidence, which is 50.1%.
Right.
And so to be substantiated as derogatory, the information has to be something that is of such a nature that it clearly reflects on unacceptable behavior or integrity or even your ability to make good, sound judgments.
That's right. There is a specific definition of what constitutes adverse information in AR-15-6. And there's a lot of leniency in that definition. You know, as we know with the definition of just about anything in the law, there is room to navigate and room to work with it. But this gives commanders who have adverse findings as part of an investigation, it gives them quite a bit of latitude in order to upload this sort of thing into your official file, which could have detrimental effects later on.
Right. The other services, like the Air Force, for instance, upload things in their IG database. It's called the case tracking system. In the Marine Corps, they upload it in the Officer Disciplinary Notebook Management System. In the Navy, they don't have a system where they upload this information, but it's the AAIP here in the Army. So what are the rights of somebody who's been found to have adverse findings in an investigation?
Well, if you're O1 and above, you have a right to respond to those adverse findings.
Okay, and how would somebody respond to those adverse findings?
Well, we recommend that you always get an attorney first. I think it's important, and we all think it's important, that you get an attorney early and often to help you navigate the different ways in which you can respond. You can respond directly to the investigation itself, pick apart the investigation, look back through the history of it, determine whether or not the IO has made sound, logical, conclusive results in his investigation, findings that is. So there's a lot of different ways you could really respond to it, but you should always do it with an attorney.
Right, and at the law office of William Helixon, not only would we help you write that, but we'd also do something else. We'd help you reinvestigate that investigation, right? There might be witnesses that weren't interviewed by the original investigating officer. There might be questions that were not asked as we review those statements. There might be evidence that's out there that wasn't collected that might reflect on a different finding, a non-adverse finding. And that's one of the things that we could do. We could bring our experience and our knowledge to bear on reinvestigating or expanding the investigation.
That's right. These investigating officers, you gotta remember, it is part of their main duty. They are not investigators by trade. They are not professional investigators. So while it's no mark on them, a lot of times the investigations are not very thorough, and they certainly have not seen as many different types of investigations as you and I have with the same level of experience.
Right, and I think it's important from the perspective of responding that you provide rebuttal evidence, and that in some instances you provide that extenuation and that mitigation evidence. What were the circumstances surrounding the misconduct? What were the facts that were going on at that particular time? And if there was anything that was an extraordinary circumstance, those should be highlighted. And you should always, when responding to these investigations, have letters from people, commanders, superiors, peers, who are supportive of you and your career. We think it's very important that you are as thorough and as complete as possible when responding to these investigations. These AAIP filings, which are a result of the investigations.
That's right. And there are times where you may have been advised by your attorney not to give a statement during the course of the investigation. However, it may be to your benefit to give a statement now in responding to the AAIP part of it, because that's also responding to the investigation. But in this instance, you have the benefit of being able to see the entirety of the investigation.
Well, that's absolutely true. And if you're not satisfied with the results of your response to the AAIP, you can always appeal that to the Board of Correction for Military Records. That's always, it's kind of like the administrative law Supreme Court is what I like to tell clients. This is the Law Office of Will M. Helixon. We are your warrior advocates. You defend the nation, we defend you.